this episode. What's this about, John?
This episode. Well, we're going to talk about the ADP. Oh, shoot, I'm going to get it wrong. American Data Privacy Protection Act, ADPPA.
Yes. I wish it was one of those better sounding acronyms where it's a word. What is that called? There's a word for that.
For when you have an acronym that
Also
says a word. Yeah, I don't know what that's called, but I like them. And I've been trying to come up with, I've got things at work that need like branding. And I've been trying to come up, actually, I have one I'm trying to think of now, but I can't come up with something. I'll work on it. We're getting completely off track here.
Yeah, we are. What's new?
Yeah. Okay, so yeah, we're doing this different. We're unprepared for this conversation. We're coming in just kind of raw, and we're just going to talk about this. So let me throw a question to you. Yeah, I mean, okay, either way. Yeah, let's start off with that. What do you know about what the ADPPA is? And
well, as the name suggests, it's really our first comprehensive privacy law here in the U.S. We have a patchwork of state legislation out, depending on the state, of course, do have really robust privacy laws, then coverage by sector. So you have FERPA for your education use, GLBA for banking institutions, HIPAA for healthcare related information. And this, really reading through it, looked like the first, bill of its kind to not be sector specific and to be mostly broad reaching, although there are terms in here that kind of make it sound like they're a bit more targeted toward organizations that make money from processing data exclusively rather than do it as, a facet of their operations.
Right. That's good. You answered like 5 questions right there.
Yes, that's true.
I know, because I was gonna talk separately about like the different states that have laws and the comprehensive versus sectoral and stuff like that. You answered them all in that one question. We're gonna be done here
please contribute though, because this is I certainly don't know all the laws statewide out there. I know California has a bunch that are really paving the way for this, but this does seem to borrow a lot of language even from the CCPA as far as definitions go too.
It does, and it makes sense for that. So like I was trying to think of like what is the problem that's being solved here. Mm-hmm. And I think that's that there's like you said, it's a patchwork. There is no comprehensive federal law, and because of that, the states are working on passing a bunch of individual state laws. I pulled up the list. So there's 5 states right now that have state privacy laws, California being the first, and they have, had their original one that they've then modified to CPRA. So California, Virginia, Colorado, Utah, and Connecticut. And then there's 6 others who have passed laws that haven't come into effect yet. And there's 12 other states that have laws that have been proposed. So we'll be up to
24. Did I do that math right?
24 I think 23.
States have thought
you were
about
close.
It.
Yeah. So 5 plus 6 was 12. Yeah, that was good though.
Yeah.
So that's like half the states
have either thought about it, written a bill up, hasn't been accepted, or have laws in place now.
Right. So clearly it's an important problem that a lot of states are addressing, and which makes me wonder, like, if the states are taking care of this individually, why do we need a federal law? So I don't know, what are your thoughts about that? Why do
aside from being, my simple gut answer is that's complicated to keep up with. I think the US tends to be very business friendly with a lot of its legislation. It takes a lot of that into consideration as bills are drafted, and I can see that in the language of the ADPPA too, which is cool. But that's my gut reaction, keeping track of all the different requirements and trying to especially boil it down to the data subject or end user and where their location is in a lot of cases is more complex than having one set of rules to follow for a set of organizations, or at least that scope covers broadly enough.
Yeah, agreed. I think it's difficult for companies who are trying to abide by 50 different laws, although I think that the overlap between a lot of those states is pretty broad. So it's not as if they're completely different, but yeah, there's different nuances in each state that you're going to have to deal with. So
I know for data breach reporting laws, it varies based on say for breach notifications, how many affected users that minimum is. That's a difference I've seen across state privacy laws that have been enacted yet.
Right. Okay. So I want to get to some stuff related to that, but let's go back to the beginning though first. So a couple of the questions I was thinking that we should talk about are, who is this protecting and who's it protecting them from? So do you want to take a stab at one of those and I'll give my opinion about the other?
Yeah. And I mean, the biggest revelation to me about this is that it is it's more of a consumer protection sort of act. Not saying that there's none that exist, but they're your CCPA, your GDPR. They're not, national. They're not national in scope to the US. So that extends to things like the right to access, delete, and correct data, which I know California has that as part of their CCPA, but it's really meant to actually protect consumers from potential privacy harms or privacy risks associated with processing personal data. I can't quite remember if it's personal data or personal information as the core definition. Did you happen to remember?
Well, I was looking, so as the name implies, the American Data Privacy Protection Act. So it's protecting data. So like some people will talk about privacy, and sometimes things not related to data come into the question. So
Right.
it's only about data for this law. And it's protecting data about individuals. So we're not talking about corporate data or like data that belongs to, or
Employment
is it
data.
about
Yeah.
yeah, so that's actually carved out as an exception, but so it protects data about individuals. Now, one thing that I don't like about this is this opening, there's a whole bunch of definitions at the start of the proposed legislation, and it defines individual to mean a natural person residing in the United States. And I like the simplicity of it, and I think that natural person language is taken directly from the GDPR, the European Union law.
Yep.
So it's fine to be on the same page there. But I don't like that it says it means natural person residing in the United States, which suggests it doesn't offer any protection for people visiting the United States, for example. And I don't like that. I think we should be offering broad protection to anyone who is in the country, even beyond, like if and I don't know, I'm not sure where to go with this one, but if there's people in other countries and their data is in the United States, do we have a responsibility to protect them when their data is here?
Right. I mean, some of the largest technology companies have, headquarters and have servers in the US. So what does that mean?
Right.
I mean, we can look at, existing data transfer agreements, I'm sure, but it's not like this provides additional, like you said, protections to those that don't live in the US.
Right. And my opinion is maybe it should.
And I'm wondering how you implement that. Like, is every business that processes data going to know where people live? Are you going to be required to know that?
Yeah, it's funny you would say that, because I remember when not to get off track, because we're not going to talk too much about GDPR here, but when the GDPR, the European Union legislation came into effect, and they said it did affect country or companies in countries throughout the world. And I was like, well, what are they going to do? Come across the ocean and do something to us over here? Like, they have no enforceability. But they do, and companies in countries around the world are spending a lot of money to abide by GDPR. So the precedent is set that you can protect people outside of your jurisdiction using laws in your jurisdiction. So anyway, that was an observation. So getting back to who it protects, it protects individuals, specifically the data about them, and who's it protecting them from. I think you started to touch on that. So do you want to go back to that? Or
Oh yeah, and this I'd actually love to hear your interpretation of this, because I was very focused on the privacy risk component, which can really unfold in a lot of different ways, and there's a lot of call out with sensitive information being a likely affected area for privacy harms, related to race, ethnicity, disabilities, all of that sensitive stuff that we would rather not have, say, algorithms making automated decisions from. So privacy harms in the form of decisions that are made based on information we might not want to be having that based off of, and especially not having the transparency for that. I see a lot of security requirements in here, so very naturally I'm thinking, I'll use the stereotypical hacker, profile here to be one actor that is supposed to be kind of gated or defended against for protecting users through this law. What are your thoughts?
Well, yeah. So we're getting into so many things here. I want to come back to sensitive data, but let me answer that question that you had first there. So who does it protect against? So because it's interesting you say that it's protecting against hackers and people like that. So the law as it's written covers what they've defined as covered entities, and then they've got like very specific things. And it's basically any person or entity that is engaged in commerce. I'm going to make it oversimplify it. And they say like if you already have to abide by the FTC law, I think from 1916, and if you're already covered by some telecommunication law from 1938 or something
FCC
like that,
probably, yeah.
But basically, after looking into each of those, it's basically this covers any business that's engaged in commerce or any person that's engaged in commerce. So let me get back to the hacker thing, because it doesn't call out like the hackers don't have to abide by this law.
Oh yeah, maybe not abide by, but being someone.
Well, but I think that, like you pointed out, there's a whole bunch of provisions in here about expectations that companies will have better defined cybersecurity practices. And those cybersecurity practices are what's going to protect the data against exposure to hackers and other things. Because you read about these breaches all the time. And usually if you wait a couple of months, they'll report on what the root cause was, like what happened at that organization that led to the breach. And it's usually something like it's a bad practice that they had in place, or somebody
seemingly benign until exploited.
Yeah, right. So if you have better cybersecurity practices in place, then you're less likely to get breached. And this law covers that. And just to be clear, because we didn't cover this, so this is not a law that's on the books right now. It's proposed legislation. It's been proposed, I think it was in July 2022.
Yep.
Was proposed by four people: Frank Pallone. I hope I don't say their names wrong. So Frank Pallone, who's Democrat from New Jersey; Kathy Rogers, Republican from Washington; Janice Schakowsky, Democrat from Illinois. Sorry, Janice, if I get your name wrong. And Gus Bilrakis, a Republican from Florida.
They did not make it easy on us.
They didn't. But I think I got through it. So it's four people, 2 Republicans, 2 Democrats, 2 men, 2 women. So you would think that, bipartisan support. But right now it's stalled. So it's not going anywhere right now.
Yeah. I imagine support for perhaps maybe the same outcomes, but different means to which that's done through the law. I'm being very generic here, but that seems to be the pattern, especially when I was observing like the dialogue around COSA last episode. There is a sentiment that yes, we need a comprehensive privacy law, but what that looks like seems to very much vary amongst senators right now.
Yeah, I attended a privacy conference, and I should remember the name of the organization that held it, but I don't. Sorry. It was at the National Press Club in DC the week before last. And there was a lot of heavy hitters in the privacy world that attended and were speaking at it. And they specifically talked about this proposed legislation and asked some of the people what their prediction was. And one of the speakers offered a very strangely specific prediction that he thought it would become legislation between, and he gave 2 very specific dates that were about a year apart. So, and that was in the next 2 or 3 years. So there's some hope that it will pass. I found an article that was written by ADPPA, and they listed, and I think it was a while ago, but they listed the problem for this thing moving forward is that people in California think that this law is actually weaker than laws that are on the books in California, and this would essentially weaken privacy protections. Which goes to another question that I thought we should talk about is when you've got multiple privacy laws covering the same thing, which takes precedence? Like which law do you have to follow if there's 2 that address the same thing?
Yeah, I thought I read something in here about preemption. I mean, of course, you mentioned it earlier in this episode, but the fact that this would preempt the state laws that are otherwise covered, or any other, regulation under the draft. I don't know if that's going to end up in its final form. And I'm, of course, paraphrasing based on, what I had observed earlier. So
Yeah.
there's one
So
indicator. And then I know there are other like non-privacy state laws, like we talked about employment laws, probably civil rights laws might be preempted or kind of carved out there. But what's your take?
well, there was a section that talks about it's very specifically mentioned some of the sectoral laws that you mentioned, like HIPAA and FERPA. And it said that if you are already in compliance with those laws that it mentioned, then you were deemed to be in compliance with this one. So it pretty much says that I don't know that that's preemption though. It just kind of says like, hey, if you're doing what they've asked you to do, we'll accept that as being good enough.
Yeah.
And I don't recall reading a specific preemption thing, I was actually surprised when I get into that thing about the article about California not liking this one. That wouldn't it be almost easier to build a preemption clause into it that just leaves the California one intact? But maybe that doesn't solve the problem that they're trying to solve, because if you have a preemption clause that says, well, these 24 states that already have laws on the books, they can take precedent, which doesn't solve the problem.
It adds that other layer of complication. Yeah, it comes full circle and doesn't really solve the problem we're facing today.
It does. So maybe the solution is to beef this up and make it as strong as the protections provided in California. And, maybe then they'll get on board with supporting it.
Yeah. Yeah. Switching gears a little bit, because this was, we're talking about the most fascinating kind of parts of this bill to us at the moment in the state that it's in right now. I don't think they called them data brokers specifically, but I remember reading that there were mention of third-party collecting entities, where those are under they're under an obligation to undergo third-party audits on their data disclosure practices. I think I read something you need to inform visitors, I believe, of your website if you're a data broker, that that's basically your business model. And they need to data brokers moving forward need to register with the FTC, so that the FTC has some log or database of all the data broker companies. And there were some fines associated with non-compliance to that, but I don't know, I thought that was fascinating. I mean, they want, FTC has some desire to, or at least those that propose this bill have a desire to kind of strengthen the FTC's oversight, kind of by rule or by law, on data brokers specifically.
Yeah, it's interesting that they are using the FTC that's already in place, and in fact, instead of carving out new laws for this law itself. The way I read it, and again, not an attorney, but the way I read it was that if you're deemed to be out of compliance with this law, then you're essentially found to be out of compliance with the FTC's law on unfair and deceptive business practices, which has a lot of teeth. They've been using that for a long time to enforce some privacy practices, I guess, because it's not laws. But it's interesting that they didn't develop something entirely new to enforce this. So the FTC will be responsible for enforcement. And on top of the enforcement part, I was looking for where the rights of action are. And there's two specifically called out, that if any of the states find that, I guess, a company or a covered entity is violating provisions of this law, the states have the right to bring civil action. But there's also civil action that's granted to individuals. So if you feel as if you've been wronged in some way, you have the right under this law to sue the company and claim damages. So that's a good thing.
And is that where the state attorney generals come in with the authorization to enforce certain provisions of the bill?
I guess it would. I guess they would be enforcing it through civil action.
Yeah, which reminds me of last episode when we talked about COSAs being also through that path of, hey, you can basically complain to your or you can sue the company, but then you can also complain to your state AG to say, hey, I don't think this company is fulfilling their obligations under COSA, of course. So it seems to be following the same model there. Yeah, but did you see anything about like a private right of action like identical to CCPA? I mean, that's not something I got into super in depth.
Well, just what I mentioned, that if there's a private right of action, that if somebody feels that they've been wronged by a covered entity, they can sue them using this law. I was looking for what the penalties might be, because when GDPR came back out, and it's fair to keep comparing things to GDPR because that's like the gold standard.
It is
right
our
now.
measuring stick right now.
It really is. So when GDPR came out, they had very specific numbers of like this huge dollar value in fines, or like a percentage of
4%, I think, of
gross
global annual
revenues.
revenues. Yeah.
Yeah. And I was looking for something like that, and I didn't find anything in it that had a specific call out. So it did say that if an individual was suing for damages, they could sue for compensatory damages, which I think would be the large one, and legal fees and stuff like that. But I didn't find specific penalties, which I wonder if they would be added, because this is just proposed legislation.
Yeah.
And my understanding is that there's significant changes can happen between proposed legislation and what actually gets enacted.
Yeah. Especially when it's using vague
missing.
language as the placeholder, right? They're using the little brackets. I've read that means
Yes.
it's very, very likely subject to change there.
Right. But what other sections did you stood out to you in this?
Well, so there's the duty of loyalty kind of.
I love it. Yeah.
It's a very, very strong phrase, kind of a very direct form of, getting agreement with organizations that have to comply with this. But it was very focused around the data minimization concept, very, very plainly. So don't collect, process, transfer data that unless it's reasonably, used or necessary to perform whatever service. It seems to overlap with other existing privacy and security laws around the globe, where it calls out that things like investigating incidents, fulfilling warranty, authorizing users, protecting the security of users, and investigating that end, communicating messages to end users, transferring assets, all that good stuff don't really count as reasons to not use personal data, which, I can see how that might be necessary, although I know not all those cases it's strictly necessary. Maybe you can obfuscate some of the personally identifying information. But there was also, though, a call out that says processing first-party advertising is okay. But at the same time, there is, I think, a right to, a separate provision that says you have the right to opt out of personalized targeted advertising. Algorithms that it went into explanation about how it's any algorithm that dictates how you see information, which is crazy because we have whole business models built off of that. So working around that would mean quite unique, kind of a rethink of how marketing can work for these platforms.
I know, and honestly, I'm not all that opposed to targeted advertising, because the difference for me is I'm seeing advertising for things I'm interested in versus things that I'm not. I mean, I don't have a problem with that, but I get the privacy implications for it. Going back to the duty to loyalty section, which I love their wording of that, and really what it's saying, this is what companies have to do. But there's a section in there that is titled the loyalty to individuals with respect to pricing, which basically says you can't punish your customers for not consenting to your privacy practices, for example.
Can't be a condition to using the service necessarily.
Right. So you can't say, well, I'm going to charge you more because you opted out of targeted advertising, for example. Which I guess I like that, but at some point there has to be a price paid for free services, right? So none of us pay for Google, but we use Google all day long.
Of course.
And the reason Google is able to provide the services to us is because we are the customer. They're making money from our activities. But I don't know, I'm rambling there. So there has to be, they have to get something out of it. There has to be something in it for the companies to do the work that they do.
And I can see, especially in more of the technology and in social media technology space, there's an argument that it is a value add to have algorithms that feed personalized more like feed data, what I'm seeing on, you know, a Facebook news feed or a, you know, insert any really social platform. So
Yeah.
I would be interested in, and of course they benefit from the advertising and in the data inputs that come with that and interacting with it and, you know, further refining what you see when and why.
Yeah.
But I can see from businesses that being an argument of it's not solely for the purpose of advertising, but, you know, showing Rachel what she wants to see based on what she's liked before, you know?
Yeah. So going back to, we had a whole episode last time about children, protection of children and different laws. So this has a whole provision for data protection for children and minors. And the very first provision of that section is a prohibition against targeted advertising to minors. So it does offer a separate provision for regular people, well, not regular people who are not minors, I guess, to opt out of targeted advertising. But it comes right out of the gate that they're, according to this law, targeted advertising to minors will just simply be prohibited.
Yeah, and that of course goes back to the problem of we have to. I think they said something about,
to
you know, if they have
identify
a
them.
knowledge of having minors on your platform, but I mean you can know that, you know, I mean, without being right there with the child using the phone, like, are you really gonna, you won't know from the source, which is that basically that whole episode, like that argument came up a lot, but doing so in a way where I guess it's reasonably expected that maybe it's a for children, although that's more COPPA space. So that's
I get
interesting.
it. What I would argue for these tech companies is that their algorithms are really good enough to know exactly what product I might be interested in and where I might be able to buy it.
Yeah,
And
they
then
can
send
infer
me that
age
target
pretty
advertising.
strong and all these other
So,
demographics.
yeah, use that same magical power that you have to know what I want to buy to make a reasonable determination if somebody is a child or not. Because it's doable within, you know, with a certain margin of error, but they could do their best.
Yeah. Now, I think it's also interesting because I believe COPPA it prohibits certain, you know, activities or, you know, data collection activities really for children under 13 without parental consent. Now, the ADPPA cites minors as being U17, you know, 18 or up is basically an adult here. So that 13 to 17-year-old area, like that would be something that's it's kind of a gap being closed in that way.
Yeah, fair. Yeah, I hadn't thought about it from that perspective. They're introducing so
they're different. I shouldn't say actually being closed, actually being open, because we are not using the same definition of minor in this way. But, you know, the parental consent is supposed to be that bridge between 13 and 17.
17, right? But it would essentially create a tiered structure that, you know, you're not allowed to do things for children up until age 13, and then things change until they're 17, and then, you know, the gates open.
Yeah. All while, you know, considering these platforms that are affected that might not be by COPPA because they're not specifically targeting children in their services, that require them to have a much more precise guess of age, right?
Yeah, got it. Yeah. So there's another section in here about corporate accountability that I liked also. And one of the things that I really liked, and I think I've mentioned this to you in the past, is that I think will be beneficial to you and me and to our industry, is that this law requires a designation of a privacy and data security officer that is, you know, essentially reporting to the C-suite. So it's really just going to grow our industry. There's going to be a lot more privacy experts needed in the corporate world, and hey, we're happy to help them, right?
Woohoo! Yeah, maybe perhaps one day we'll end up in the spot of security. Maybe we're already there, but where there is essentially a negative unemployment rate, where there is so much demand that we just don't even have enough butts to be able to fill in those seats. So the education in the understanding, like you said, required for extending these rules to the organizations that might not be covered or as comprehensively by the patchwork of laws in place today would be cool. It also reminds me of, we're going to take it back to GDPR, but how they have a requirement to have a data protection officer. And there was also on the topic of corporate accountability, the requirement that the CEO and the PO, and I believe the CISO, maybe that's if you have, a CISO, not a CPO at this point, but I guess
Right.
assuming you'll need to implement, you'll need to fill that role. Actually, that's a wash. But you have to annually certify with the FTC that there are internal controls in place that can, reasonably be used to not just safeguard information, but also review the practices and, really certify that it's on par with your expectations as outlined in this bill. And that really reminds me of the, Sarbanes-Oxley Act, also requiring oversight mechanisms, really literally for the purpose of corporate accountability with these rules.
Yeah, I mean, it raises the bar for corporate executives, which is a good thing. I don't know what the penalty would be for them, certifying something that's not accurate, but I'm sure it's
steep,
significant. Yeah, which is good. So it means that they're really gonna have to pay attention to this, because I think a lot of companies, they pay attention to cybersecurity practices to the extent that they need to protect themselves. But what's being required of them now is you need to have practices in place, and good practices that the FTC is going to define what those are. But you have to have them in place to protect people and natural humans and the data about them. So it's not about protecting your company. You have to, they'll have to protect their company through protecting people and their data. It just changes the game, which is a good thing.
And that's how I kind of mentally, differentiate between security, not holistically and across the board, and not in particular examples, but separating the incentive or the kind of, mentality between security and privacy practices, of privacy being oriented toward the consumer or data subjects under GDPR, whereas security is the corporate assets that make you money that you want to protect, and all the information that flows within and out of it that makes your business happen.
Yeah, there's a lot of overlap between the two, but I think that companies generally focus on the cybersecurity part of it, and they are providing protections for the parts of privacy where there's overlap, but those other parts of privacy where there isn't overlap, and where there's no requirements for them to either not use our data in ways that we don't want them to, or other things. It's just the Wild West. There's some, like you mentioned, healthcare. There are some controls there, but companies that are operating in sectors that don't have the sectoral laws in place, or in states where they're not state laws in place, it's a hodgepodge. So I think this would make things fair and standard across the board, and give us as consumers a reasonable expectation of what's happening with our data. There was one part in here that I thought was interesting. I'm not going to see it in my notes, but my recollection of it was that they were going to develop a common, centralized or standardized opt-out mechanism.
Yeah, I remember reading about that too.
And I was intrigued that it was kind of vague in the language that was written, but basically it said that within a couple of years, we're going to develop some sort of process that uses an industry standard that people can once you opt out, you can opt out from services or data use practices across the board. But it essentially referenced a functionality or a technology that doesn't exist today. So they, not that it can't be, clearly it can. But I thought that was interesting. I was surprised. I wasn't expecting to be surprised by anything that I read in this bill. That surprised me.
As a consumer, I would love that. I mean, there are other mentions of, prohibiting certain dark patterns and making it, difficult to say opt out of processing or really understand what's going on based on all the notices you have. There's, words like clear and concise, unambiguous. I would personally love that. And I interpret it as, giving the end user, the consumer, a way to not need to jump through hoops in order to, get what they need to get done, and making it very clear and obvious, and leaving no room to say, hey, like they knew in this sub page in this checkbox, and they could have clicked out of these 3 places in these separate locations. It can be complicated to navigate for a user that doesn't really know where to look and where to go for that information.
Yeah, and about the user part, there was a separate provision, I think, early in the very early stages of it that talked about. Let me see if I can find it here. No, I'm not going to find it. Oh, here it is. No, didn't find it. Anyway, it essentially required awareness. So after the law is passed, I guess the FTC would be responsible for essentially an advertising campaign of letting people know that this law is in place and these are what the protections that are afforded to you are. And I like that because it's going to be something new. People really don't understand privacy. People
It's a
already,
lot of what you can't see. I always talk about
yeah,
how hard it is to you can explain to folks. You can, I mean, until you experience really a data breach, is that a time where you'd be looking and going, hey, what did I do wrong as the consumer? But it's not tangible. You're in this day and age, you're basically trusting that organizations have what they need to have in place. Things like this, mandatory review, especially for like data brokers with an actual entity that's responsible for keeping companies accountable, is a mechanism on top of that that can reinstate trust for companies that might be, I don't want to say facing PR problems, but like those that might not have the trust of the public yet, because it's just not something we can see and make an assessment for ourselves clearly all the time. We're getting there with better controls and privacy dashboards on a lot of different services, at least by my observation. But it's not standard across the board.
Yeah, and I think that because of, again, going back to GDPR, but because of GDPR, it's more common to see privacy notices and those more obvious opt-in, opt-out choices showing up on your screen. So I think that those types of things will become more prevalent with a comprehensive law in the United States. And just having those things kind of in your face for people will kind of force them to recognize it. And I know, unfortunately, some people will see it as being irritating. Like, why do we get these pop-ups asking me this question? They won't understand that it's really, this is here to protect you. But it will also inform them. They'll become more aware of it. And hopefully individual people's awareness about privacy will, I don't know, inspire them to care about it and protect it and, get engaged in the process.
In all the ways that, it's in our control, right? I do wonder though, if, the overflow or, this new, it's supposed to be concise, it's supposed to be simple. But that middle ground of reaching comprehensive enough to truly explain everything that companies could do with your data and for the purposes that, you're supposed to be agreeing to. It's the problem of the terms of services that we have today, where it's pages and pages of legalese to really get that, get the coverage and get your, responsibility met as a organization. But for end users, I'm concerned that it'll be, like you said, a bit lengthy and a bit annoying. And it actually does the opposite with, I don't want to say creating fear, but going, oh, wait, this was happening the whole time. Maybe I shouldn't use this service if it's more of an elective one where you're not maybe doing business on it per se. So I hope, it encourages education about it and just awareness overall. And so we have more to look out from, and we can actually understand the role that we play in a data ecosystem better, even if it doesn't immediately strike any change for users. It'd be great if they went and did their own research following that, but they're just trying to log on to the service. It might be a little mosquito bite for them.
Well, that's why they need people like you and me working on it on their behalf. And I'm in favor of this legislation, like, maybe some changes to some of the wording or provisions. I honestly wish it was a little bit closer to GDPR, only because it's easier for us to follow rules that are similar. And,
universal.
Some of these are really the same as GDPR. They just use different words to describe them.
Right.
Like you said, they don't call processors. They call them, I don't know, third-party entities or something like that.
Yeah.
But overall, I think it's a step in the right direction. So yeah, thumbs up from me.
Yes, same here. I'm excited to see what changes are made, because there did seem to be a lot of, what do you call that? Cliffhangers. You're almost looking for the information on maybe how many affected users or what these fines look like, what these new standards or this new universal framework looks like that an agency is supposed to develop. But it's our job to keep up with them. So I guess until next episode, when we get an update, we can start diving into what's changed.
yeah, stay tuned. So thanks for the chat, Rachel. I'll talk to you for the next one.
Yes. See you, and thanks for watching,
All right.
everyone.
Bye.